Good evening, everyone. My name is Sharif El-Gabaili. I'm the Editor-in-Chief of the Westminster Law Review, and it's my absolute pleasure to welcome you all tonight to the first Westminster Law Review National Debating Competition. Before I introduce the teams and tonight's judges, I'd like to briefly run through the running order of tonight's event, just to give you an indication of the wonderful evening you have ahead of you. Round 1 will consist of 3 head-to-head matches, each of 8 minutes. Each team member will speak for 2 minutes. At the end of the match, judges will assign the scores. At the end of the entire round, the 4 teams with the highest scores will progress to round 2. The motion for this round is, this House believes that deception as to gender negates sexual consent. This topic is based on the case of McNally versus R at the UK Court of Appeal. Round 2 will consist of 2 head-to-head matches, each of 10 minutes. This will differ from round 1 in that after each team member speaks once, there will be an opportunity for one team member to speak for a further 1 minute. At the end of the entire round, the judges will announce the winners of each match and the finalists. The motion for this second round is, this House believes that, in light of the Security Council's response to the situation in Syria, the Council has become increasingly irrelevant in maintaining international peace and security. Round 3 will be the final round. This will last for 10 minutes, with each team speaking for a total of 5 minutes. The topic for this round will be announced after round 2, when the teams will then have 30 minutes to prepare their arguments. And the rest of you can help yourselves to the lovely refreshments at the back. Of course, at the end of this, the judges will then announce our winner of the overall competition. You also have an agenda in front of you, I believe, so if you get a little confused, then you can always refer to that. So on to our teams. We have a wide range of establishments, not just undergraduate, but also those who are doing their law conversion. Team 1 is from Hertfordshire and is made up of Christopher Abrahams and Joan Ammer. Team 2 is from Brunel University and is composed of Rachel Frith and Nolanda Twitt. Team 3, representing Lincoln's Inn, are Kieran Purawal, doing her BPTC at City, and Vincenzo Volpe, doing his BPTC at Kaplan. Team 4, representing Kingston University, are Claudia Reeves and Shane Danino. Team 5 from City University are Eleni Denanis and John Lodwick. Team 6, although also from Lincoln's Inn, are a further 2 BPTC students, Jade Earle from BBP and Lucy Limbry from City. Our esteemed judges for this evening are Mr. Richard Blackburn, an associate from White & Case, Mr. Andrei Vasilescu, barrister and director at Fulham Legal Advisory Centre, Victoria Brooks, visiting lecturer of the University of Westminster and academic editor for the Westminster Law Review, and Mr. Martin Kubash, a solicitor from Baker & McKenzie. Last but not least, we have Mr. Serhat Yilmaz, who will be serving as our timekeeper for this evening. So without further ado, let us begin this evening's debate with our first match, which pits Team 1 from Lincolnshire, arguing for the motion, versus Team 6 from Lincoln's Inn, arguing against the motion, this House believes that deception as to gender negates sexual consent. Teams, would you please take your places?
Good afternoon, ladies and gentlemen. My name is Joan Ammo, and I'm on the proposition side, and I'm here to persuade you and bring you to agree with me that deception, in terms of lying to someone and telling them that you are one gender when you are really another, would really negate sexual consent. I believe that to deceive a person in any way in order to gain sexual gratification is always wrong and could never result in valid consent. Let us consider the Oxford Dictionary definition of consent, and I quote, "Permission for something, a particular thing, to happen where any change must be made with the consent of all partners." Now let us consider any agreement where the terms and conditions have to be adhered to. If any of the terms and conditions are violated, the contract is made void. Let's now apply it to the case where a woman gives permission to a man to sleep with her. This man now turns out to be a woman. Has she given consent to this man, who is actually a woman? No. The purpose of the act has changed. The purpose of the act was initially for a woman to sleep with a man. The purpose has now changed for a woman to sleep with a woman. Under the Sexual Offences Act, section 76(2), it states clearly that if the purpose or the nature of the act has changed, then the consentee, the woman in this case, did not give consent. Ladies and gentlemen, tonight, please follow me and believe that deceit could never allow for sexual consent. Thank you.
Ladies and gentlemen, I act for the opposition and I oppose the motion that deception as to gender negates sexual consent. Let me deal first with your rebuttals. You point to the fact that sexual act is a contract. Well, indeed it is, but it's not. If you see the person, you agree, offer agreement, there is indeed a contract there, and why should anything you later that you're mistaken by negate that? Let me move on to some of the points that I would like to deal with. First, I'd like to deal with conditional consent. We often see gender deception as worse than other forms of deception because it's a violation of our personal morals and our standards. Let me use the analogy with religion because, like gender, religion is something personal to us and says something about how we wish to live our life. If we have, for example, a Jewish woman who agrees to have sex with a man on the premise that he is also Jewish, but later finds out he is in fact Muslim, this does not negate sexual consent, and why therefore should gender? I'd like to move on to a second argument that gender is in fact a social construct with male and female either ends of the spectrum. There's all sorts in between. Why should we criticise someone who is, for example, transgender, who sees themselves as male, acts as male, and has a sex change to be perceived as male? Why should he therefore be accused of rape when he believes himself to be male and feels male? Ladies and gentlemen, there are my arguments, and I hope you agree with us. Thank you.
Good afternoon, ladies and gentlemen. My name is Christopher Abrahams. I'm the second speaker of the proposition. Right. First thing I'd like to say is sex is a physical act. The opposition pointed out someone could feel like a male inside, or another woman could feel like a woman inside, etc., etc. But that doesn't come out of you and then have sex. Sex, if you don't have male genitalia or female genitalia, sex does not exist. You need those fundamental components to have sex, honestly. So, if we have those fundamental components, surely that, if we need those fundamental components, surely those components should be a fundamental thing which both parties should know about. Both parties should understand what those components are. I use the example of a drink with salt and sugar. If you put salt in a drink, you put sugar in a drink, it's just like gender, it's completely different. It's not like, they may look the same, they might seem the same, but is completely different. You would take your drink back if it had salt in it, if you expected it to have sugar in it. I kind of refer back to the case of R and McNally. Because of the period of time, and the fact that these two people had a relationship, it cannot result in consent. In terms of what the opposition said, and a man who can potentially see himself as a woman and a woman who can potentially see herself as a man, we're talking about deceit. Deceit has connotation. The word deceit has connotations of intent, and you intend to deceive somebody. So, on that point, ladies and gentlemen, I would like to end here and then say that I hope the Court of Appeal took our case, the common law took our case, so I hope that you too also take our case. Thank you.
My lords, ladies and gentlemen, I have 2 points I wish to make. First, if this House accepts that deception as to gender can negate consent, then it must also accept that the criminal liability of a defendant turns upon the subjective attitudes of the complainant. And I say this because in the case of McNally, what Lord Justice Leveson said was that it would only be capable of negating consent in particular circumstances, and those circumstances were when the particular complainant had objections to same-sex encounters. So what this seems to suggest is that where the defendant is confronted with a complainant who has less liberal attitudes, he's to be guilty of a criminal offence. Where he's to be confronted with somebody who has more liberal attitudes and is open to bisexual encounters and who may not find the outcome or the deception so objectionable, then he's not guilty of a criminal offence. Now, this is clearly wrong because it's not the way in which our criminal law functions. The criminal law punishes acts which are intrinsically and objectively treated as wrong in principle and not wrong for particular persons. And this is necessary in the interest of certainty. A defendant or a person must know before he acts those acts which are punishable and those which are permissible. My second point is that the Court of Appeal has consistently recognised that not all deceptions will negate consent. Certainly, deceptions as to a person's wealth will not negate consent. Now, this seems to suggest that it is found that there is something unique about homosexual encounters that regard the complainant as being worthy of legal protection, where otherwise he or she would not be had they been deceived upon other matters. Now, this is clearly a value judgment made by the Court of Appeal that certain acts are so abhorrent or unusual as to be worthy of protection. Going to bed with Charlie and waking up the next morning and finding out that he is in fact Charlotte is objectionable, but going to bed with a prince who turns out the next morning to be a pauper is not worthy of protection.
Sorry, I had to interject there just to keep things fair. It's a very contentious point, but we have to stay within our time limits here. So thank you to both teams. Whilst the judges deliberate, perhaps you could vacate the stage and our next two teams could come up. Team 2 from Brunel on my right here, please, and Team 5 from City on my left. Thank you very much. Team 2 from Brunel on my right here will be arguing for the motion. Team 5 from City on my left will be arguing against.
We will be arguing that yes, deception as to a gender does negate sexual consent. Now, consent is generally defined as an agreement or a permission to carry out an act. Now, Section 74 of the Sexual Offence Act states that a person consents if they agree by choice. However, there are some circumstances which invalidate consent, such as deception. As the Sexual Offence Act states that consent is where a person agrees by choice, In the case of McNally, it states that the complainant did agree to have sex with a male, namely Scott Hill, but not a female posed as a male. This in fact does impede in the victim's freedom of choice, because she never actually got to choose whether she could sleep with the male because it was just generally a girl. Now, in the Section 3 of the Law Amendments Act, it states that a person shall be guilty if anybody procures any woman or girl by false representation. False representation is generally seen as deception, and therefore, if this act sees it as unacceptable, then it shouldn't be accepted anyway. Now, in the case of R.V. Williams, 1923, sexual act via consent was obtained, but it was classed as void. And since that was in the earliest 20th century and was not acceptable, then why should it be acceptable in the 21st century now? So basically, the deception as to a gender does negate sexual consent. Thank you very much.
The decision in McNally should be criticised, and it should be criticised for 3 reasons. Such a law, we will find, is going to be unenforceable. It is discriminatory against intersex and trans people, and moreover, it contributes to sexism by weighing so heavily on the notion of identity and gender. Such a law relies necessarily on the existence of discrete, unambiguously differentiable gender categories. Science tells us that gender is a spectrum, and so the creation of such categories is necessarily going to be difficult, and it will be difficult to apply practically. This very difficulty reveals the discriminatory nature of this law, as intersex and trans people will necessarily be precluded from providing adequate disclosure in sexual encounters, protecting themselves from the risk of legal action. Imposing a law requiring compliance with discrete gender categories necessarily marginalises people who cannot lay claim to those categories. Are we really to label intersex and trans people as deceptive and rapists simply because they cannot conform to such strict categories? Furthermore, this sends a message that gender and identity are inextricably intertwined, something which takes us backwards towards a time when gender stereotypes were firmly entrenched. For the idea that gender and identity are entwined is, of course, the fundament of sexism. Therefore, this law not only fails to protect the people for whom Lord Justice Leveson deemed protection is necessary, but it goes further to actually cause societal harm through discrimination and social damage. Thank you.
It is fair to say that not all deception can nullify consent, and that a defendant is only culpable if the deception impedes the victim's freedom of choice, and therefore deception in areas such as wealth and profession do not nullify consent. Only when factors such as these change the nature of the sexual act will the consent be considered void. In response to my colleague at this point, I would like to make a distinction between the case of McNally and the rights of transgender individuals. In the case of McNally, it is accepted that the defendant struggled with issues of gender recognition. However, in order to justify not disclosing the defendant's birth gender, there should be no doubt in the defendant's mind as to the gender and identity that they now associate with. This was not supported by the behaviour of McNally, as at the time the defendant was still living as a female, and surely the victim had the right to know this. The difference lies when the individual has completely adopted a new gender and identity, as would be the case for transgender people. Now, although this is supported by the Gender Recognition Act of 2003, which provides a legal right to change your gender, it is clear that the law in this area is still insufficient. As it stands, the law does not consider whether deception as to gender will invalidate consent. It is not right to subject transgender people to this level of uncertainty in regards to such an important part of their lives. Now is the time for the government to act in order to introduce a statutory exception to protect the rights and the liberties of these individuals. Thank you very much.
Ladies and gentlemen, I wish to advance two arguments as to why deception as to gender or sex does not negate sexual consent. First, I'd like to talk about the link between consent and physical integrity. Why do we place such a high value on consent in sexual relations? What is it, in other words, that distinguishes the case where there is deception as to the wearing of a condom, one example that Lord Justice Leveson talked about in his judgment in McNally, and a case where there is deception as to the age or wealth of one of the sexual parties? In the first case, one of the parties loses total control over what is happening to their body. In the second case, they don't. That is what is fundamentally at stake with the notion of consent. Therefore, deception as to sex or deception as to gender does not negate consent, because at no point during the act does the party being deceived lose total control over what is happening to their bodies, and that is the role that consent plays. For my second point, I'd like to counter a claim that Lord Justice Leveson made in his judgment. Indeed, it was the central claim of his judgment. That claim was that deception as to sex during a sexual act alters fundamentally the sexual nature of the act. In other words, he's asking, or he's telling us why deception as to sex changes the nature of the act in comparison to deception as to age or wealth. What he's saying in saying that the sexual nature of the act has changed is he's legitimating the objection of the person who's been deceived, who says there has been the moral quality of the act has changed because I've had sex with someone who's of the same sex as me. This, I argue, is a lurking homophobia in the judgment. The law did have the opportunity to shape social attitudes for the good, but in fact, in McNally, it reinforced pernicious social attitudes. Thank you.
And so, the last match of the first round, Team 3 on my right from Lincoln's Inn will be arguing for the motion, and Team 4 from Kingston on my left will be arguing against. Thank you.
Good evening, ladies and gentlemen. My name is Kiran Parawal, and I'm arguing in support of the motion that deception as to gender does negate sexual consent for two reasons. Firstly, it removes the person's freedom and choice, and secondly, the significance of the deception. Firstly, it removes the person's freedom and choice. Lying about their gender is not a trivial matter. Gender is seen as an integral part of a person's identity, and deception about this is of a serious nature. And if we look at Section 74 of the Sexual Offences Act, in relation to consent, it states that a person consents if he agrees by choice and has the freedom and capacity to make that choice. By someone not having the freedom and capacity to make that choice and someone lying about their gender, that they are in fact a male when they are a female, this is essentially a violation to the person's freedom over their own body as to what they can do with it. So therefore, when someone is deceiving someone, the receiving party doesn't have the full details of what they are consenting to, and ultimately, as I've said, this removes the freedom and choice of them. In relation to my second point, the significance of the deception, and this point interlinks with my first submission I made. It may be viewed, and the other side may argue, that consent is consent regardless of who the other party may be, and that penetration can be carried out either by a male or a female. But in fact, as we've seen in the McNally case, a person can disclose their appearance, something called stealth. Therefore, deception is of a significant nature if it's not disclosed, and deliberately deceiving someone, the receiving party believes that their gender is different as to what it is. And if we look at Section 76 of the Sexual Offences Act, in relation to the presumption of consent, it states that consent is nullified if a person intentionally deceives the complainant as to the purpose of the relevant act. And therefore, I argue in support of this motion that a deceiving party clearly has the relevant intention into deceiving this party. Thank you.
Esteemed opposition, esteemed judges, I would like to endorse the argument that ineluctably the deception of gender does not negate consent. My notion will go by the argument proposed by the defendant of the council, and the defendant of the council was the venerated Mr. Wainwright, who argued that the sexual consent was not negated by gender, likewise age, marital status, or wealth. I believe that this could be distinguished by other forms of deception. Other forms of deception could be the deception of sexually transmissible diseases, and that could amount to inevitable negation of consent. I believe, and likewise, I will use his argument to endorse how the deception of gender does not negate consent, and ineluctably, via the procedure of sexual interaction, an individual provides consent upon what they see. And usually, as seen in the McNally case, there's been many presentiments to the defendant, the complainant being aware that the defendant had certain characteristics that may pertain to a female. So, inevitably, it's quite unequivocal upon the sex of the person that the consent is given to. For this point, I would like to argue that deception of gender does not negate consent, and it's fairly derisory in comparison to deception of other forms, such as the lying of sexually transmissible diseases or other forms of deception. For this manner, I would like to argue that deception of gender does definitely, or should not, negate consent, likewise as age, marital status, or wealth, as argued by Mr. Wainwright.
Good evening, ladies and gentlemen. I argue in support of the proposition that deception as to sexual identity does negate consent. I would like to make 2 points. The first point is that deception is not an omission, and therefore liability in this case is going to be easier to establish. And the second point is that sexual identity is not just a mere attribute to sexual acts. The terms deception and non-disclosure have been used interchangeably during this debate. I am not supporting the motion that non-disclosing your own identity negates consent, because that would mean entering the realm of omissions. And we know from the line of cases arguing HIV and consent that the courts are reluctant in accepting this. A deception, however, is not an omission, it's an action. A person is deliberately and intentionally lying as to their gender in order to obtain sexual consent from the complainant. Had the deception not taken place, the consent would have most likely not taken place either. The consequence of this argument is that every issue which is connected with the right of privacy, for example, of a transgender as to their own sexual identity, or any issue as to disclosing your sexual orientation doesn't take place, because liability doesn't impose an obligation to disclose in the first place. It imposes an obligation not to lie. I would just like to make another point. The definition of sexual acts prevents itself those acts from being asexual, that is, without a sexual identity. It follows that when somebody consents to an act which is of a sexual nature, it also consents to a sexual identity. And therefore it is for this reason that consent would be vitiated, because it's not given genuinely. Thank you.
Good evening, ladies and gentlemen. I'm arguing against the idea that deception as to gender does negate sexual consent. I believe that the whole idea of deception is a situation where a victim consents to a sexual act as long as a certain condition is observed, like in the case of R on the application of F v DPP, where a wife wanted her husband to only engage in sexual activity if he wore a condom. As a result of him not wearing one, she became pregnant and took the case to court. That is a clear deception of something. He is not doing something that she wanted him to do, whereas in this case, it's extremely different. I believe that the case of McNally, it's a very difficult case to deal with. There are many issues surrounding that would be a whole completely different debate. However, McNally did not intend to deceive the victim, which is different to my colleague's point here. Deception, she had genuine feelings, but she made an unfortunate set of choices which were exacerbated by her confusion with sexuality and her body. She told her victim and her mother that she was going to go through with a sex change, which she wanted to continue their relationship after she had done this. Now, talking about wanting a sex change is enough to get protection as a transgender person under the Equalities Act 2010, specifically section 7.1, which states that the person has a protected characteristic of gender reassignment if the person is proposing to undergo, is undergoing, or has undergone a process for the purpose of reassigning the person's sex by changing physiological or other attributes of sex. Now, as a result of this, she clearly did not receive any protection under this Act in the case and was suffering from gender dysphoria, which is a condition that occurs when a person does not identify with the sex that they were born with. As a result of this, GD, as gender dysphoria, is not a crime in any civilised society, and to argue that someone should be prosecuted because of it, it doesn't make any sense at all. Just to finalise my point, McNally, in the case, didn't inform of her birth gender and received 3 years initially. However, in the case of RVEB, which my colleague mentioned earlier with HIV, the defendant did not receive anything, and that's why I believe deception does not negate sexual consent.
You can take your seat if you like. I'll just ask you to take your seats now, please. Thank you very much. There'll be a very brief period of time whilst the judges deliberate, and then we'll move on to round 2.